Okay, good morning. Welcome to a session of oral arguments at the Fifth District Court of Appeal. Our first case this morning is Lemon versus People's Trust Insurance Company, 21-2771. The other members of the panel joining me today are Judge Wallace, Judge Rand Wallace, and Judge Carrie Ann Wozniak. These arguments are being live streamed and also being recorded for future reference so that members of the public can see it. Each of you will have 20 minutes aside for oral argument. Mr. Strobel, if you want to advise me how much time you wish to reserve for rebuttal when you first get up here, I'll try to help you in that regard, but there should be a clock on the screen to help you as well. If you have your cell phones, make sure they're in the silent mode. And with that, we'll go ahead and proceed.
Good morning. May it please the court, Matthew Strobel, representing the appellants in this case. I got the clock there. I'm going to try to reserve about 3 minutes. Okay. And this is an appeal involving a case where legal error occurred in a number of ways. I think the most basic way that it occurred is that the final judgment in this case that was entered cannot possibly support either common law accord and satisfaction or statutory accord and satisfaction. Statutory accord and satisfaction cannot possibly be supported because the two final elements were never reached by the jury. So that all the other issues aside, with that defense being unpled and inapplicable, the jury verdict does not possibly assert it. Similarly, the verdict does not possibly support a common law accord and satisfaction because the jury never found that there was a pre-existing dispute.
Mr. Strobel, if we agree with you on these arguments and we reverse and remand, what would we be remanding for? Because it looks like the jury did not determine damages and there were some other defenses. So yes. What would happen in the trial court?
So I did my best to lay that out. One of the spots I put that was at the end of the reply brief, and it would be two ways. So part of our motion, we move or we seek that this court could find that a directive verdict should be entered in our favor as to the accord and satisfaction defenses, based on the fact that the jury found that there was a supplemental claim and that the plaintiff had the right to submit a supplemental claim. So if it was granted in that basis, it would be sent back. There would still need to be a jury trial, and that would essentially involve the jury determine whether we proved there were more the damages and the amount of damages. Alternatively, as I lay out and at the end of the reply brief, if the court finds that as a matter of law we shouldn't have had directed verdict on the defenses, and instead the jury needed to find whether there was a pre-existing dispute or not, then it would just be a new trial that would include the jury making that determination, and that determination for the jury would include determining whether there was a pre-existing dispute, which was then a subsequent agreement reached to resolve that dispute, as well as making a finding as to the amount of damages. So regardless of which of our issues are found upon, because the jury did not get to the question of damages, it would require a new trial. But the way the basis for the ruling could result in there being less issues for the jury to determine.
What about the other defenses that were pled? I think there was waiver, there was estoppel. Would those still be at issue?
Those would be at issue if this court finds that. So let me just have a moment to grab the verdict, just to remind myself what was left.
It looked like the jury stopped when it made its findings on the accord and satisfaction.
Correct. Yeah. So so question one, the jury found that there was a supplemental claim, and then the next question was what's at issue on this appeal, the accord and satisfaction defenses, and because of that, it never got any further. And as I'm looking just at the remaining possible defenses for People's Trust, Okay, they would have another possible defense on there that the jury never reached as well. So one of the things they claimed as a defense that was sent to the jury was they were saying that they invoked the right to repair and somehow that was not complied with. So that would be another defense for the jury to potentially determine, but that was never reached. So basically, if you look at the verdict form, that was issued, depending on how the ruling, was issued in this case, it would make it so that the jury does not have to consider accord and satisfaction if the court agrees that they had a right to submit a supplemental claim, or that would be sent to the jury and sent in a proper manner, which is the way that we, pursuant to our instructions, where we had, just like the defendant had up until the day of trial, a specific requirement for the jury to find that there was a pre-existing dispute that was later resolved by a subsequent agreement, mutual agreement between the parties. And that is, I think, an important factor in this case. If you look at the history of the case, and we laid it out.
Mr. Strobel, under your client's interpretation, when would the ability of your client to supplement the claim close or become too far removed?
Yes, so I believe it's all the same. There's a statute that gives them up to 3 years. Their policy incorporates that statute, which gives them up to 3 years. And in this particular case, the supplemental claim was initially submitted in June of 2017, which is much less than a year. It was, a few months. So basically, you have the payment, 2 letters issued at the same time. One of those letters saying, "Hey, you've got a right to submit a supplemental claim." That was undisputed at trial, that an insured should have a right to submit a supplemental claim. The jury found that there was a supplemental claim. It's undisputed that damages were discovered during the repair process. They got the check to replace the roof. They started doing that, found damage in the garage, also found damage in the office. And all that was reported by June of 2017. So it was reported well within the 3-year period. It was reported within a few months. And I believe the way that works is you get 3 years to report the claim, and I think you have 5 years to file a lawsuit. And in this case,
was any portion of the original offered amount? I believe there was some reference in that to a ceiling claim. Is that correct? I understand there was a roof and fence, but
yes,
also there was a reference to the ceiling claim. How is that different from the spots that were reported on the ceiling?
Yeah, so I do lay that out in our fact section. So the payment was issued for the exterior of the roof, and as you referred to, the fence, and the interior bedroom only. And that is clear from the estimate that they made their payment on. Also, all the testimony show that at the time the claim was reported, at the time People's Trust did their inspection, at the time they issued payment, that's all either the plaintiff, the insured, or the insurer were aware of. Neither of them were aware of the fact that there was damage in the dining room. That was discovered, the office, that was discovered later. And therefore, no one was aware of it. It wasn't included in their initial payment. So what was issued was not disputed. They paid for the roof and they used the money to replace the roof. They paid for the interior bedroom. There was no dispute as to that. What was disputed and what became disputed was later on, the insured became aware of a dining room and the flooring in the office, as well as the garage, and sought to submit a supplemental claim. And that's where People's Trust ultimately ended up taking the position that payment that we issued when you told you could submit a supplemental claim, and before anybody of us knew about that other damage, somehow encompasses that.
Mr. Strobel, you've talked a lot about an undisputed claim, but you also talked about in your brief, and that's what I want to focus on, is what the actual agreement was between the parties. The check says full and final settlement in accord with claim settlement. So to me, the claim settlement could either be the initial claim or it could be all possible claims. And so I want to ask you, what evidence was there in support of either position?
Yes, so twofold. So that the letter you're referencing was sent on December 19th, 2016. That's the date that payment was issued. And it was issued with 2 other things, a separate letter sent on the exact same day, specifically stating in accordance with the policy, Florida law, that there might become a time in the future where you become aware of additional damages. And if that happens, you could submit a supplemental claim at that time. So in this case, and it's very important to the fact that there's got to be a pre-existing dispute between the parties, is very short window. The insurer.
Well, you keep referring to pre-existing dispute, and what I'm suggesting to you is, even if there's a dispute on the original claim, is the check that was given for the original claim only? In which case, it doesn't really matter whether it's disputed or not, if there's no evidence that it was also intended to cover any potential supplemental claims?
I would say that, yes. I would say in this case, even as to that payment, they didn't even have evidence that there was a dispute as to those damages. Now, at the end of the day, that's not really what the case involved into. But in this case, there was, even as to that initial payment that they issued, for there to be accorded in satisfaction just as to that, there would have had to been a disagreement, the insurer thinking the roof cost more, the insurance company thinking it costs less, and then they have that dispute, and then on December 19th, subsequent to that, they issue the payment and the insured accepts it. So even as to the roof, for example, there was no disagreement or back and forth between the parties, where even accord and satisfaction could exist as to that portion. At the end of the day, we don't think that that's really pertinent for the decision here, because the trial was really about the damage in the office and the garage, and that's what the jury found to be a supplemental claim. But yes, in this case, there wasn't even, they couldn't have even properly found accord and satisfaction as to their initial payment, because it isn't a case where they issued a payment for the roof and the insurer thought it wasn't enough, and then they thought about it. That never occurred. So in the most basic sense, they never even got to that point in any facet of the claim. So as I indicated, if you we went through the dates, they're pretty short because it happened very quick. Claim was reported, payments issued on December 19th, 2016. And 2 letters sent on that date, and one advising the insured that a supplemental claim could be submitted. And in addition to that, even the estimate that the payment was based on, which didn't include the office, didn't include the garage, also explained that a supplemental claim should be based on. So, just on that fact alone, that the jury never made that determination for accord and satisfaction, we believe that reversal is required.
The motion for a directed verdict at the conclusion of the evidence, was that directed solely to the accord and satisfaction defense, or did you make any argument as to any of the other affirmative defenses?
Just as to those, we made it as to both of the, in this case, they have 2 different accord and satisfaction. So we made it as to the common law, with our position being, hey, it's undisputed in this case that a supplemental claim arrived later. No pre-existing dispute, no evidence of it. In our initial brief, we cite testimony from all of their witnesses where they agree that an insured has a right to submit a supplemental claim. So we moved forward on the common law, and then we moved forward on their statutory defense for similar reasons, but also that they did not plead it at all. We also cited to a case from this court where, that's a statutory. You won't find that applying in a insurance claim, because this is a breach of contract case. And as this court explained previously in the decision, that's if you are possibly, it's a uniform commercial code. If you've got a bill and you dispute the bill, you can submit it that way, but it has absolutely no application to a case like this. And we also moved for directed verdict as to their statutory defense on the basis it's inapplicable. And then also because it was never pled, and that's kind of telling in this case. But
was the motion directed toward the other affirmative defenses? And this is somewhat of a follow-up to Judge Wozniak's question about equitable estoppel or fair to meet conditions preceding or the set-off.
I don't believe it was, Judge. I believe we just moved as to that defense. That's what we, believed was improper. And, we did agree that there was other questions for the jury to make a determination on, but those questions were never reached by the jury because this defense was improperly given to the jury, so they never got reached. So there would be still a jury trial required, but we believe that first, that jury determination should not include accord and satisfaction because the evidence does not support it and it's contrary to a supplemental claim. Or alternatively, that the jury has to independently determine, the elements of accord and satisfaction. That never happened here because the instruction that was submitted by the defense, contrary to their own affirmative defenses, contrary to their own jury instructions that they themselves had submitted. They themselves submitted up until the last day of trial a jury instruction and verdict form requiring the jury to find that there was a pre-existing dispute. And then it was only, right before the case was going to the jury that they submitted a new one, which we objected to, including in writing, that they changed it and then tried to eliminate that because I think the evidence clearly showed that there was no evidence of that, and certainly not, favorable evidence to submit to a jury. So, for those reasons, it's our position that it needs to be reversed for a new trial, and that new trial can either eliminate the need for us to deal with the accord and satisfaction defense, or have it submitted to a jury where the jury is actually given an opportunity to determine whether the elements were satisfied or not. So those are our primary reasons for a reversal. And at just about 5 minutes, I would reserve my time for rebuttal if there's no further questions.
I want to confirm that I understand the distinction between your first and second arguments in your brief. So the first argument is because there was the ability to bring a supplemental claim. There's no accord and satisfaction. Does that mean we don't even get into the elements of accord and satisfaction, the dispute and settlement and all those things? So it just doesn't apply. We don't even get into the elements. It doesn't matter whether there was a dispute or not. We're just done. But then the second argument, we actually get into the elements and whether there was a dispute.
Yes, exactly. So as our first argument and what the basis of our directive verdict was, that by definition, the supplemental claim is damages the parties are not aware of and they become aware of later. And indeed, that's what all the letters testimony said it is. Case law is very clear that's what it is. And the jury found that there was a supplemental claim. So by very definition, if you have a supplemental claim, which the jury found, there can't possibly be accord and satisfaction because you can't have a dispute of damages at the time you issue a payment when both parties aren't aware of them until later. And by definition of supplemental claim, that's what it is. So yes, that's our first position, is that jury found there's a supplemental claim. By definition, a supplemental claim is damages discovered later during the repair process. And because of that, and that's what the case was for and what the damages the jury would ultimately be asked to award, there can't possibly be accord and satisfaction. That runs afoul of the definition of the supplemental claim, and the jury's finding that there was one. So
but you would still have to look at the language on the check, right, that was issued by the insurer, because there could still be accord and satisfaction depending on what the language of the check says, and whether it's adhere or not, you can argue. But it's not an automatic get out of jail free card. No,
certainly not. But it's the language is one factor. Then there's many other factors, including that it was disputed, and many other factors if they are allowed to submit a statutory defense, which the jury never reached those questions that would even possibly support that. So no, it's not a get out of jail free card, but by nature, they couldn't have disputed damages they didn't know about and then reach a subsequent agreement as to those damages because the jury found that there was a supplemental claim, and by definition and all the evidence supported it, that's damages discovered in the future. So yes, if it was a different factual scenario where they had been fighting over the amounts of the repairs needed for the office and the garage, and then later they issued a payment, then the jury could possibly properly find that that defense applies. But that was not this case, nor was it the jury's finding.
Thank you.
All right, thank you.
Thank you.
Mr. Swift.
Good morning. I appreciate the opportunity to speak with you on behalf of my client, People's Trust. We view this case as a very simple case for this panel to decide whether or not Florida law has changed since 1887 when Sanford v. Abrams was decided and the court enunciated a rule of common law.
Mr. Swift, before we even get there, I want to ask you about the December 19th letter and the check. The check refers to, full under settlement claim, full and final settlement in accord with claim settlement. So, that claim there is singular, not plural. So it seems to me, are we talking about a full payment of all claims or just the original claim? And then maybe to answer that, if I look at the December 19th letter, I don't know if it's 19th or 9th, but but you refer to payment pursuant to the attached estimate, and the estimate only goes to the original claim. So my question is, what evidence is there before the jury that that payment wasn't intended to fully settle the original claim only versus the original claim plus any subsequent claims?
Sure. So, and I just want to clarify, we're talking about, and I understand your question, but this is just foundational. We're talking about a singular hurricane claim that was reported with different elements of damages. So the letter itself talks about the issues, but you've jumped ahead a little bit because the purpose of the letter and the purpose of offering a settlement was because People's Trust had elected to repair the home, and whether or not what happened or what the discussions were, we don't know, but the letter specifically says, we are offering you a full and final settlement in lieu of our option to repair the property because of our difficulty in getting a work authorization. And so I think everyone on this panel has had at least one case involving People's Trust and their business model of repairing homes. And so in the face of times where they're challenged to repair a home for whatever reason, whether it's the insured themselves objecting or someone else on their behalf, they have at times taken this alternative approach to offer a complete settlement of the entire case in lieu of repairing the home.
But that's not what the letter says. The letter says your endorsement of this check memorializes your acceptance of the scope and amount of damages we previously reviewed. So first you have the previously reviewed, and then goes on and says, and as reflected in the attached estimate, it is offered solely to bring about a complete and final resolution of your claim. So the letter says that your acceptance of this check means that you're agreeing to the scope and amount of damages which we previously reviewed and which are referenced in the attached estimate. And can we agree that what was included in the supplemental claim was not previously reviewed by your client and was not reflected in the attached estimate?
We can agree that the damages, I guess, so to speak, that were later presented were not presented to People's Trust at the time of their original inspection. However, I would challenge the Lemons' recollection of the facts as to what was actually existing at the time that settlement was made, because of Mr. Lemon's testimony that they had discovered this damage the day after the hurricane, and that the additional damage to the garage occurred no later than 1 month after they returned home. Hurricane Matthew was October 6th, so even giving them the benefit of a couple of more days, they would have discovered that damage in early November. They didn't report the claim until November 30th. So whether or not his memory was accurate or not, or what he remembered, the actual garage damages based on his own testimony existed. The second part,
even if that's true, which I know there's a dispute on, but even if that's true, how do you explain the language memorializes your acceptance of the scope and amount of damages we previously reviewed and as reflected in the attached estimate? Because it says your endorsement of the check memorializes this, which seems to say your acceptance of the check means that this check is for these amounts, the ones previously reviewed and the ones reflected in the attached estimate.
I think the important thing about that, and I have one other point on the damages to make, and I'm just saying it out loud so I don't forget. The important point for that is that there's consideration for that offer. The consideration is we are waiving our right or an election to repair your house. So that the language, I don't think the jury had any trouble interpreting the language. This is a jury case. A lot of the cases cited in the appellant's brief are summary judgment cases where the courts have decided. But the language itself says we have the right to repair. We're having trouble getting the work authorization to do the repairs. Here's an alternative method of settlement. We're going to give you this amount. You're going to agree that this is the full amount. I understand the language that you're saying and you're interpreting it precisely or in one particular way. But then it goes on to say, if you don't agree that this is your claim, don't cash a check or let us know, and we will then repair your home. And these people never, ever, throughout the entire trial, even made an effort to return the check and say, we don't want this settlement. We
Is
want
there anything in the 2nd December 19 letter that advises the insured that acceptance of this check is a settlement of all future potential claims, which you would agree they had a right to file for up to 3 years, right?
Well, I would agree that under certain circumstances, they have a right to a supplemental claim within a certain period of time. That it's important to understand, though, that in the context of the repair model, that would have been handled through the repair process, whether or not those claims that they had were related, et cetera, different. But I think the language itself is perfectly specific.
Well, point to me the specific language you're relying on, which advises the insured that acceptance of the check means that they're accepting the check for all future potential claims.
Sure. Well, I mean, what you've already read, as well as the title of the letter that says claim settlement letter, as well as the memo on the check itself, which says full and final settlement. And
the claim is singular there. I mean, it seems to me if you have an original claim and a supplemental claim, by definition, that is plural.
Yeah. Well,
and your check and the letter refer to a singular.
I respectfully disagree with that assessment. And I think if you look at the Valadares case, a case that's actually cited by both of us, that the appellant indicates allegedly stands for the proposition that there needs to be a dispute. That was a case where there was a consent order, but there was a water damage claim. And the water damage claim is referenced in the opinion as the sole pending claim. And the court says that they accepted payment without reserving their rights to claim more damage. And there were no facts at issue later. So they refer to the water damage as the claim. Same thing we have here, which is the hurricane damage is the claim. The fact that.
Right. And I think at the beginning, I referenced that the check could be ambiguous. And that's what, but if it's ambiguous, then you look elsewhere. And that's the problem I'm having with your letter, because your letter seems to indicate that it's for what's in the estimate.
Well, I think the jury was able to understand that, and the jury made that decision. This was not a summary judgment where the court usurped the jury and saying, well, wait a minute, we are needing to have a jury trial on this issue. This was submitted to the jury. Nobody claimed they were confused by anything.
Well, let me ask you this. Did anyone from the insurance company testify that it was the intent of that payment to settle all subsequent claims?
No, we relied on the letter itself as well as the language on the check for that purpose. I just do want to get back real quick to one other point regarding this entire, what was actually disputed in the complaint itself, which is in the record. This is after the appellants already replaced their roof, well after. They replaced their roof in January 2017. This lawsuit gets filed in December 2018. And the record, in paragraph 9 of the original complaint, they're claiming that we breached the policy by failing to adequately reimburse them for the roof claim. So we have a dispute that would have had to have existed way back when we made the payment already, as evidenced by their pleading. And this is also evidenced in the record in their reply to our affirmative defenses, where they say that we waived by not properly paying the claim, et cetera. So again, I think that what's most important, I think, for us on that issue is that we have a situation here where we have two different parties saying the law on accord and satisfaction is two different things. And so I'm segueing back to where I was in my argument, which is that this court is allowed to provide us guidance on what the law actually is, because you have these cases streamlining what common law accord and satisfaction is and basically ignoring the fact that it applies to non-liquidated claims. And in this particular case, we asked the trial court to apply the law as it's supposed to be. In Sanford v. Abrams and the Rudick v. Rudick case, all of the cases cited by all the parties, if you follow the trail backwards, they go back to Sanford v. Abrams, which was a case where there wasn't even an agreement as to the cost or the amount that would be paid. And the court found that there was an accord and satisfaction based upon the fact that it was an unliquidated claim. So we don't believe that the law has ever changed. We believe it's easier for courts to cite, quick elements of what the law should be. But when they talk about a pre-existing dispute, they're talking about situations that are subject to dispute.
So your position is that for common law and for statutory accord and satisfaction, it can be unliquidated damages or a dispute?
Well, the statute is clear. The statute says either unliquidated or subject to a bona fide dispute. The reason why there's a distinction there to me in the statutory version is that there has to be a negotiable instrument. That's the sole difference. I take issue with the appellant's argument that somehow the statute is limited to some situations involving goods or something like that. That's not at all what it is. It has nothing to do with that. It has to do simply with a methodology of codifying what the law is for one particular way of resolving it, juxtaposed to the 725.05, which is a statute that applies to liquidated claims where they say you can't use a negotiable instrument. Essentially, you have to have a release.
I guess when I was analyzing, trying to understand the difference between a dispute and unliquidated damages, why they're both there, I was trying to think of a situation where there could be unliquidated damages where there's not a dispute. Like there could be a dispute where there's liquidated or unliquidated damages, but is there ever unliquidated damages when there's not a dispute?
Well, yeah, I don't think that there is. I think that the whole idea of a dispute really, I mean, again, I'm not trying to twist the court's words, but it's subject to dispute. As was argued, the estimate is an estimate. Mr. Lemon testified at trial as a real estate agent that he was well aware of the fact that estimates are estimates, and sometimes for his clients, someone wants to replace a roof and it's $5,000 and somebody else would do it for $2,500. And I use that example for him. And the estimate does say that Mr. Strobel talked about earlier, which is, we don't know, there may be more damages, but that's the whole reason why they're offering to compromise the claim. They're not going to waive their right to repair this home if there's not a complete and full settlement. It wouldn't make any sense. I think the letter is very clear, especially when you combine it with the check. But getting back to the issue is there a distinction between common law accord and satisfaction and the statutory version? The only real distinction there is that the statutory version requires there to be A, a negotiable instrument, and B, the conspicuous statement.
Mr. Swift, you said the letter is very clear when you combine it with the check, but when you combine that with the estimate, that seems to be where the clarity kind of goes out the window. You're seeming to say that the estimate, when you combined all three of those, opens it up to any claims that have not been adjusted, because there was no mention of the spotting in the ceiling and there was no mention of the damage to the floor. So doesn't the estimate kind of defeat your argument with regard to the clarity of the check and the letter?
Not at all. I don't think it does at all. I think that.
So is there any reference to the floor damage in the estimate?
No, the floor damage was never brought to People's Trust attention. That's unequivocal.
What about the damage to the garage? Was there any reference to the damage to the garage in the estimate?
No, as indicated earlier, the garage damage, again, according to Mr. Lemon's own testimony, was present well before People's Trust inspected the property, but he did not bring it to their attention. So why he did that or didn't do that, I don't know the answer to that question. But this is not some conditional offer saying we're going to pay you this amount you're going to release us for these particular damages, and then later on come back and say, okay, we took that money, now we want more.
Are you suggesting that the reference to the estimate, which was attached to the letter, served no purpose?
I don't think it served no purpose. I think what it did was it gave the Lemons the opportunity to look it over, compare that to what they believe their damages were, potentially talk to contractors about getting repairs, and make an informed decision as to whether or not they wanted to settle the claim for that amount of money. And they elected to do so. I mean, this is, just addressing a point made earlier, and this ultimately was not decided specifically on the timeliness of this supplemental claim, but it's undisputed that when this letter came in from their public adjuster in June of 2017, the public adjuster testified he was requested to give information and never contacted anybody. And then a lawsuit got filed, and then a lawsuit got dismissed, and then another lawsuit got filed. All of this time without there being any kind of supplemental claim made. Again, that's kind of an aside, but the point is they had all of this time to decide, do we want to accept this as a full and final settlement? They were well aware during the initial lawsuit that there was a claim that this was a full and final settlement. As a matter of fact, I think it's either briefed or somewhere in the record that there was a summary judgment motion pending on that claim, and there was actually a 57-105 sanctions motion pending because of the fact that there had been no supplemental claim. So they wait all this time, and then on the second lawsuit claim for the first time, well, we thought that we could make a second claim. That's not what was going on here. To me, it was abundantly clear. They received two different letters. I don't know if they actually got them on the same day or they were sent the same day. One letter talks about an election to repair. It's a completely different process. The other letter says we're having a hard time being allowed to repair your home, so we need to go ahead and try to effectuate a settlement, and they elected to do that. To me, we didn't need any more evidence of intent. The jury found that there was a mutual intent to resolve the claim. This is a jury decision that it was well within their purview. And I think I'm running out of time, but I want to just address a couple quick things if I can. First of all, there was sufficient evidence to get past the directed verdict. I mentioned a few things already. There's affidavits filed in opposition to a summary judgment to try to avoid that, saying we disputed it. Mr. Lemon testified, that he disputed it. We talked about the allegations in the complaint. So clearly there was plenty of evidence to get to the jury. And again, I think secondarily, the issue is for this court is really, does common law accord of satisfaction apply to both disputed claims and to unliquidated claims? We believe, again, that the jury made the right decision on this case. No other evidence was needed. The jury didn't have any trouble finding a mutual intent to resolve the entire claim. No argument was made that that particular claim or the way the jury instructions were submitted was incorrect, other than the inclusion of the word unliquidated. Mr. Strobel specifically said that on the record. Thank you, unless there's other questions.
Any other questions? Okay, thank you, Mr. Swift.
Thank you.
All right, rebuttal. You have 2 minutes and 18 seconds left, Mr. Strobel.
Okay, thank you. I just want to point, because it's not just the estimate. I want to point to in the record page 721, that's plaintiff's trial exhibit 1. And the second of two letters that were sent on December 19, 2016, first page, last paragraph, the People's Trust own letter specifically says, in quoting, sometimes the scope changes as repairs move forward and new conditions are discovered. If that happens, you have the right to supplement your claim to include newly discovered damages so long as they are damages which are covered under your policy. And then they refer to the estimate, which also says you have a right to submit a supplemental claim. So it's not just the estimate, it's People's Trust's very own letter sent on December 19, 2016, advising the insured in accordance, it's the same thing in the law, it's the same thing in the policy. They have a right to submit a supplemental claim for newly discovered damages later found. And the jury in this case found that they had a supplemental claim for newly discovered damages that were found. That was a jury finding on question 1 of this verdict form. And you can see the jury's finding that there was a supplemental claim is supported by all the evidence in this case. So it's People's Trust's very own letter said, if you discover damages in the future, here's your money to replace the roof. If you discover damages, you can submit a supplemental claim. The insured did exactly what you would want them to do. They used those funds, they replaced the roof. They became aware of additional damages, and the jury agreed that they did. And all the evidence supported the fact that there was a supplemental claim for damages discovered later on. And based on People's Trust's very own letter, which was accurate, they had a right to submit a claim for those supplemental claims. The jury found that they had a supplemental claim. And because of that, the later questions, including any other possible defenses that they had, what the amount of those supplemental claims was, should have been determined by the jury. So based on that, based on their very own letter sent on the date they issued the payment, we asked that the court find, in accordance with their own letter, that they had a right to submit a supplemental claim for newly discovered damages.
Okay. Thank you both for your arguments. And we will be in recess until 11 o'clock.
Thank you.
Thank you.